We like to say that we don't tell people how we do things how we do things. And so sharing information with you and me receiving information from you contributes to building those fundamental relationships that allow us to understand one another better and to understand the subject matter better. And so I know you kept questions to the end, so I do want to respect that rule. However, I'll leave that as it is. And so, as our lovely moderator indicated, I've had the honor and the tragedy of being involved in some class action litigation associated with the forced sterilization of Indigenous women in Saskatchewan and Manitoba. This has since been raised in other provinces, and there are now pending class actions in several provinces. The issue came to the attention of lawmakers, and very recently, Bill S-250, which specifically criminalizes non-consensual, coerced, or forced sterilization, did unanimously pass the Senate and is going into first reading in the House of Commons, something that at the outset of this debacle, we never thought was possible for the simple reason that it was indicated, no physician becomes a physician to hurt people. I think those were the words of our Prime Minister. Notwithstanding, we have a tremendous body of law dealing with consent and what it means. And so it has evolved into this veritable doctrine that informs us on how the inalienable right to bodily autonomy entrenched in Section 7 may be infringed upon, and it is subject only to proper and informed consent. Now, as everybody in this room will clearly know, eugenics ideology is something that has been around for, well, too long. And although it's been formally repudiated and pieces of legislation in in Alberta and British Columbia repealed, the vestiges remain and kind of find their heartbeat within the unfettered discretion of clinical discretion. And so that's something that this case has often seen. Well, there's a medical reason for sterilization. Well, there's no medical reason for sterilization without consent, that much we know. And so if we look at I'm going to be jumping around a little bit here, so please bear with me. If we look at the criminal context, we see at Section 43 or 45, Article 43 or 45 of the Criminal Code, that physicians and other authorities benefit from relative immunity when it comes to criminal charges associated with aggravated assault that are connected to procedures deemed for the benefit of a person. Now, you can imagine how for the benefit might leak in some of that eugenics ideology, depending on where that particular physician is coming from in their lives, their lived experience, and what types of stereotypes that they've internalized. And, if we really think about that and we line it up against the doctrine of consent, which frankly is very, very clear from our client's perspective, there's no real need to change or augment or read in or read out of the doctrine of consent. It is abundantly clear. It has 4 fundamental tenets, and those 4 fundamental tenets are the subject of their own doctrinal bodies. One of them, of course, is voluntariness. So absence from coercion, no fraudulent misrepresentation, such as you can reverse it later. No coercion, such as you can't see your baby until you agree to this. No coercion, such as you will die if you have another child. So that's one of the fundamental tenets, is voluntariness. The second is capacity. Now I know, and I'm kind of scared to even go here in this room, especially because I am loath to suggest that a birthing woman does not have capacity. That's not what we're saying. What we're saying is that a birthing woman does not have capacity to consent to a procedure with irreversible consequences on her fertility during said birth. And I don't know how many of you have had children in this room, but I can tell you I did it twice. And this is going to be a bit of an off-color joke, but I'll tell you, I got asked to be put out of my misery, and that wasn't consent to maid. A lot of things will happen while you are birthing a child. You will say a lot of things. It's extremely painful. It's very stressful. Maybe that's not the case for all women. And gosh, I wish I was one of those. But that simply isn't the case in most instances. What we also know is that when the placenta detaches from the uterine wall, it is the highest spike known to the human body. I see the men's eyes kind of, oh, we're saying those words. Yes, when it detaches, it is the highest surge in oxytocin in the human body that is known scientifically. And so what is oxytocin? It's the bonding hormone. It's the love hormone. You'll see some unusual compliance, whatever you need, as long as I have my baby and I can focus on that. And so there are peculiar and particular things happening to a birthing woman, her body, her cognitive ability, her psychology that aren't deeply studied and not very well understood. But the fact of the matter is, I mean, it's a big deal. Making a person's a big deal. And so from our client's perspective, it's leave that sacred space alone and talk about whether you ever want to do it again later, once you're through it. So capacity, understood from in that context, really means, is there capacity to consent to that particular procedure at that particular time? Does a woman have capacity to consent to an emergency C-section? Well, of course. Does a woman have capacity to consent to an epidural? Well, of course. But there's no urgency. A tubal ligation or getting your tubes tied or whatever it is we like to call it is never an emergency. It is considered non-therapeutic. And if it's non-therapeutic, you can discuss it later. And then the third criteria, or the third pillar to the doctrine of consent, is specificity. So consent has to be specific to the procedure itself. Now you can imagine in the throes of labor, it perhaps isn't the ideal set of circumstances for the surgeon to start explaining exactly what the Pomeroy technique is in terms of tubal ligations. And I'm not sure that the birthing woman may have ears for it at the time. I can tell you I got an epidural, and the anesthesiologist came in and wanted to give the 15-minute spiel, as they are required to do. I had no interest in listening to what he was saying. I was far more interested in the administration of the drug. But that, again, is a different procedure. So specificity attaches to the procedure itself, which requires explanation. It also attaches to the particular physician. So when we're talking about this procedure, that specificity cannot be discharged to any other person other than the person doing the operation to explain it. The last pillar relates to information, so informed consent. And this, of course, is, we could go on for far more than 8 to 10 minutes about what informed consent means. But it attaches kind of to the third pillar, in a sense, in that information must be provided. Full disclosure, appropriate to the circumstances, risks, benefits of doing the procedure, risk, benefits of not doing the procedure, quintessentially options, other options, is really, really important to share with someone who's considering a birth control method. And that information has to be imparted in such a way that the person understands what is being imparted. There is voluminous case law indicating that a patient who is in a stressful circumstance, who has just heard some distressing news, or is otherwise afflicted by, an amount of nervousness, doesn't necessarily have the ability to assimilate that information in the way that they need to meet that requirement of consent. And so our clients would posit that birth and delivery probably fall into that category. And very importantly, the patient has to be given an appropriate amount of time in an appropriate environment to consider the information that's been imparted, to pose questions, to come to a conclusion or not. And so in essence, in the kinds of cases that we are seeing from dozens of Indigenous women coming forward indicating that they were not afforded these courtesies, that just simply wasn't the case. There was no information shared, or very little. Does that mean I have 5 minutes left? Okay. There was no information shared, or there was very little information shared. And were they in a headspace that they were able to assimilate that information in the throes of labor? Probably not. So with that in mind, what we face is a very clear spectrum with respect to what is required of the doctrine of consent to allow for an infringement on the inalienable bodily autonomy of a woman. What we don't have are effective remedies and mechanisms to empower those notions. And so people have gone ahead trying to do this in a variety of different ways. There have been individual actions. There is one in the NWT currently. That particular physician was disciplined by the College of Physicians. He was heard saying by the anesthesiologist during the procedure, which procedure was only intended to remove one ovary and one tube. He was heard by the anesthesiologist saying, and I quote, "Let me see if I can find a reason to take the other one." And so he was disciplined. And during the disciplinary hearing, what he said was, well, she said she didn't want any more kids. Now, how one makes the jump between not being certain or not wanting any more children and somehow wanting to remove the reproductive organs, I will never know. But these are the kinds of thorns that live within that clinical discretion that we really have to get at in aligning it with proper and informed consent. And so on the criminal component, some things are moving and they're moving, nicely. Hopefully it'll go through the House of Commons. This is an issue that has affected women internationally as well. And that's important for people to know. This is pattern of conduct. This is something that we see that is rather prevalent in South Africa, in Namibia, in India, in Bolivia, in Peru. In the 1990s, over 300,000 Quechua women were literally dragged out of their homes and sterilized without their knowledge or consent under the Fujimori regime. And they continue to fight for reparations. They continue to fight for systemic change in that country. These issues arise in Indonesia. They arise in the United States through the IHS, which is the Indian Health Service. They arise for other populations in the United States. Just recently, compensation was legislated out of the state of California for the non-consensual and unknown sterilization of African-American women in federal institutions. They receive $17,500 US each. This is an issue that is arising in Sweden with the Sami women. It's an issue that's arising with Roma women in Eastern Europe and elsewhere. We have heard an indistinguishable pattern of conduct by those in positions of utmost authority in the face of those who depend on them in extremely vulnerable circumstances. And so, what is the solution to this? We like to say it's multi-pronged advocacy for the lawyers in the room. Class action won't fix it, the law won't fix it. Not alone. Policy changes won't fix it alone. Criminalization won't fix it alone. Awareness won't fix it alone. International attention won't fix it alone. And we know that because we went to the UN Committee Against Torture and Other Forms of Cruel and Unusual Treatment. They gave directions to Canada. They unequivocally called non-consensual sterilization torture. And that's the only thing that got Canada moved just a little bit, to their credit. And now we have what's called the Survivor Circle for Reproductive Justice, which launched on November 1st. And it is tasked with providing healing resources to survivors of non-consensual coerced and forced sterilization. And so we see some changes. We see some innovation. We see some movement. But in attacking these systemic issues, systemic problems require systemic measures. And so if you take anything away today, apart from my really cute doctrine of consent, please take away that when you're looking at these systemic problems, think about all their moving parts and which branches you have to tie in. Thank you.
Thank you very much, Alisa. It always struck me that, given the fact that we have this very important Supreme Court decision in Reeve in 1986, we still have to deal with this issue in Canada. I'm sure you will have a lot of questions at the end of the presentation, and it's not just my rule, by the way. Now we are moving to Seema Mohapatra. She's a tenured professor and holds a MD Anderson Foundation Endowed Professorship in Health Law at SMU Dedman School of Law. She's an expert in health law and bioethics. Her research focuses on healthcare equity, the intersection of biosciences and the law, assisted reproduction, and public health law. Her work has been published in esteemed journals, including Yale Journal of Health Policy, Law, and Ethics. She co-edited Feminist Judgment, Health Law, rewritten and co-authored as well Reproductive Technologies and the Law. Professor Mohapatra serves on the board of directors for the American Society of Law, Medicine, and Ethics and Population Connection. She also co-chairs the Health Justice Initiative and is frequently consulted by the media for her expertise. Holding a JD from Northwestern University School of Law and a master's in public health from Yale, her early career included practicing health law at leading firms in Chicago. So the floor is yours.
Thank you so much. Thanks so much for having me here today. I so appreciate the invitation to come back to the University of Ottawa for this terrific conference. And today I'm going to be discussing assisted reproduction and reproductive justice in a post-Roe and post-2024 election world. A warning that this is going to be more US focused, so a bit of a departure for some of the other panelists. And the United States has had a need for reproductive justice in the assisted reproduction realm for decades, and even more so now with the fall of Roe versus Wade, the case that provided a floor of constitutional protection for abortion. And now with the recent election, with the presidency and both the Senate and the House in Republican hands. So what I plan to do today is introduce the reproductive justice framework, which I assume all of you are quite familiar with, and discuss what this would look like in the assisted reproduction realm, and discuss some of the legal barriers to reproductive justice in the ART realm. And then I'll posit how Dobbs, the case that overturned Roe versus Wade, and the recent election could bring the United States closer to recognizing fetal personhood, which would have a significant impact on assisted reproduction. So when we talk about reproductive justice, we don't just mean reproductive rights. Reproductive justice is a movement led by Black women who felt unseen in the mainstream reproductive rights movement in the United States. And it began in the 1970s when a group of Black women, frustrated at a feminist conference that was mostly with white women, gathered to voice concerns. And the conference focused heavily on abortion, but the Black community was also dealing with things like forced sterilization and systemic issues like child protective services overreach and problems that were just not being addressed. So reproductive justice kind of broadened that conversation. So it wasn't just the right to avoid having children, it was the right to have children and to raise them in safe, supportive communities. And so how does infertility care and assisted reproduction fit into the framework of reproductive justice? Those pursuing ART technologies like IVF or surrogacy are clearly exercising one tenet of reproductive justice, the right to have children. The American Society of Reproductive Medicine recently adopted a more inclusive definition of infertility that recognized single individuals and LGBTQ+ couples as being infertile. And this broader definition has the potential to expand insurance coverage of ART, helping to break down barriers to achieving reproductive justice in this space. But there's a disconnect between ART and equitable access to it. Individuals without partners or those who require donor eggs and sperm often face significant financial hurdles in the United States due to limited insurance coverage. And so this raises an important question about how the law, whether insurance law or abortion law or healthcare policy can be leveraged to improve access to ART. So strengthening these legal frameworks would be essential in bolstering the right to have children and advancing reproductive justice. So the medical literature highlights significant inequities in assisted reproduction. And my data is US focused, but while many people across different, all racial groups experience infertility and don't use ART, the disparities are especially profound among Black and Latinx women. So Black women are twice as likely as white women to experience infertility, but are 50% less likely to seek out infertility care. And white women are the most likely group to use ART, and Black and Latinx women are the least likely. And so these disparities obviously point to clear hurdles in achieving reproductive justice in the realm of infertility and assisted reproduction. And in order to address these gaps, we need to tackle systemic barriers such as access, affordability, cultural stigmas that disproportionately impact marginalized communities. Now, why do these disparities exist? So there's obviously in one slide, I'm not going to be giving you that answer, and there's many gaps in the literature. So partly because race is often self-reported or not reported at all. So the data actually may underestimate the problem that we have, but we know there's several contributing factors. One is the lack of insurance coverage for infertility care. Additionally, the fields of reproductive endocrinology and fertility clinics are predominantly white spaces. Black women often report feeling out of place in clinics filled with images of white babies and facing a lack of Black sperm and egg donors. And the lack of diverse providers compounds the issue, making it less likely for Black patients to find racially concordant physicians, which studies show promote trust and outcomes. So on top of this, some Black women report being subject to offensive questions about their sexual history, and have justified mistrust stemming from historical mistreatment, which contributes to the stigma and resistance towards ART. So we need to address these disparities with cultural sensitivity and systemic changes in representation in the medical field and policy reform. Now, I have some screenshots here of different studies. What can we do about these disparities? Until recently, the voices of Black women speaking about their experiences of infertility was almost absent from the medical and sociological literature. So, while the inclusion is a step forward, there's a long way to go. And it's really important to amplify the voices of marginalized communities and focus on these populations and incorporate their perspectives to help achieve reproductive justice in ART. Without having true representation of the affected communities, it's difficult to craft effective solutions. And so researchers and advocates have to prioritize this work in order to bridge these kinds of gaps. Some states in the United States have insurance mandates requiring private insurers to cover IVF. While these mandates increase access, they often exclude LGBTQ+ couples and single individuals, limiting their impact. A recent study found that states with insurance mandates see higher utilization of IVF across all races, but Black and Latinx individuals still lag in utilization and lower live birth success rates. And so while these mandates improve access overall, they disproportionately benefit white and Asian women who experience better outcomes. And so we need to address these inequities. Another approach to addressing these gaps would be Medicaid coverage of fertility care. Medicaid in the United States is a government-funded healthcare program that provides free or low-cost medical coverage to low-income individuals and families, similar in many ways to, or some ways to, Canada's publicly funded healthcare system, but it's not universal and it varies significantly by state. So currently there's only one state that offers, New York is the only state that offers fertility care Medicaid coverage. And there was a recent attempt to get that in Connecticut that failed. And this highlights systemic racism as disproportionately high percentage of Black and Latinx adults rely on Medicaid compared to white and Asian adults. So expanding Medicaid to cover ART could have a much greater impact on kind of addressing this infertility access gap. So now I want to kind of transition to how recent court decisions and the recent election will have an impact of possibly worsening this rather than, improving this. And so the Supreme Court's 2022 Dobbs decision, which overturned Roe versus Wade, has major implications for IVF. By giving states the power to fully regulate abortion, it creates uncertainty around the legal status of embryos. So if a state decides to define life starting at conception, that implicates unused embryos that could be classified as persons, potentially criminalizing their destruction and use or donation for research. So this would raise costs, limit services, and make access to IVF even harder than I already mentioned in these states. And so women, patients and clinics now face ethical and legal hurdles with fears of liability that kind of stifle innovation. And women, particularly in marginalized communities, may face increased scrutiny over miscarriages or decisions involving embryos. So I have two quotes here from the Dobbs opinion. So Justice Alito focused on the quote, history and tradition of US law to reject abortion rights. And that raises additional concerns for IVF as these technologies or ART in general, they lack historical precedent and are vulnerable legally. Justice Thomas also suggested reconsidering other rights like marriage equality and contraceptive access, which could also further implicate ART. So, these developments call for vigilance, especially since abortion and related restrictions often disproportionately harm communities of color. So, fetal personhood appears to be the ultimate goal of the anti-abortion movement. And the Dobbs decision leaves the door open for states to pass laws recognizing fetal personhood. So Project 2025, which was spearheaded by the Conservative Heritage Foundation, explicitly includes fetal personhood in its policy agenda. It advocates for defining life at the beginning of conception and seeks to influence federal agencies such as the Department of HHS, which is, as you might have heard, Trump has nominated Dr. Oz to be the CMS administrator within, which is Centers for Medicaid and Medicare Services. To reject abortion as healthcare and promote life from conception to natural death as its framework. So if implemented, these policies could result in stricter abortion restrictions and pose significant challenges for technologies like IVF, where embryos might be classified as legal persons. And so this agenda closely aligns with Donald Trump's previous conservative policies and embeds Project 2025 into the broader Republican strategy, even though Trump probably hasn't read the many hundred pages of Project 2025. Already he has started to announce certain changes that are right from Project 2025. And so there's many potential implications for reproductive rights and ART. And so it's really important to be examining and addressing these kinds of proposals in both academic and policy discussions. Now, this is not just theoretical, because in Alabama, we did have a case that recently recognized an embryo as a legal person. So this is the LePage versus Reproductive Health Services decision. It was the Alabama Supreme Court that, basically this marked a very critical turning point for IVF because it recognized frozen embryos as legal persons under Alabama law. And so the ruling directly affects how embryos created through IVF are managed, potentially criminalizing their destruction, their donation for research, and any other decisions about unused embryos. And so, this decision risks restricting access to IVF. In the aftermath of the decision, there were fertility clinics and hospitals in Alabama that temporarily halted services, citing the legal uncertainty and the potential liability surrounding embryo handling. And so this illustrates how this was a totally kind of unrelated case, but it was a wrongful death case, but how these can the decisions can actually disrupt the liability of access to ART. Now, I'm going to skip this. I just want to, basically talk about I only have a minute left. So I want to talk about what's next for reproductive health care. And if the Trump administrations and Republican-led states push for personhood that define embryos as legal persons, there's going to be a profound impact on IVF. And so, although this is going to have a lot of, there is not a filibuster-proof majority in the US government, this is probably the direction we're headed. And so we need to make sure that we are being aware of what is going on, watching for personhood language and federal decisions, which has already been coming down for the last couple of years, and watching how despite the promises and the way that Trump declared himself the father of IVF, we probably will have a limitation of access and not an expansion of access. So thank you very much.
Thank you very much, Seema, for this update since the 2024 election. We're going to hear next to a talk from Audrey Ferron Parayre, my colleague at the Civil Law section at the University of Ottawa, the Faculty of Law. Audrey, elle est professeure agrégée à la Faculté de droit. Elle est aussi membre du Centre de droit politique et éthique de la santé qui organise cette fantastique conférence aujourd'hui. Elle est co-directrice de l'Observatoire pluridisciplinaire sur le devenir du droit privé. Elle concentre ses recherches et son enseignement sur le droit des personnes, le droit de la santé, l'effectivité du droit et le transfert de connaissances. Elle utilise les méthodes de recherche empiriques autant qualitatives que quantitatives. Ses études doctorales ont exploré l'effectivité du consentement aux soins pour renforcer l'autonomie des patients. Donc, elle a été soutenue par différentes bourses. Elle a aussi mené des recherches à l'Université de Montpellier, à l'Université Paris-Descartes, donc active sur le plan international également. Ses travaux actuels portent sur le droit de la santé reproductive des femmes, en particulier sur les violences obstétricales et gynécologiques et sur l'utilisation du droit comme outil de prévention, mais c'est précisément sur les violences obstétricales que porte sa présentation aujourd'hui. Alors, c'est à toi la parole, Audrey.
Merci beaucoup, Michel. Je m'excuse d'avance pour la voix. C'est pas le stress, c'est une extinction de voix. Là, j'attends en fait que les diapositives apparaissent. Voilà, excellent. Donc, je vais vous parler aujourd'hui des violences obstétricales et gynécologiques. Je vais parler en français, mais les diapositives seront en anglais. Et sentez-vous très à l'aise de poser des questions English or French at the end. Donc, ce que je vous propose de faire dans les 15 prochaines minutes, ce sera d'abord définir qu'est-ce que c'est la violence obstétricale et la violence gynécologique. C'est un sujet de recherche qui est relativement récent, qui est un peu méconnu. Illustrer aussi certaines manifestations qu'on a pu ressentir dans la littérature, mais aussi dans les différents projets de recherche qu'on fait. Puis ensuite, explorer quelles sont les réponses du droit, est-ce que ça fonctionne ou pas, selon les données qu'on a. Donc, ce que je vous propose pour débuter les définitions, ce sont quelques extraits de la littérature qu'on retrouve simplement dans les derniers mois. Donc, j'ai pris 4 articles qui ont été publiés au cours de l'été et de l'automne 2024 pour voir un peu comment les auteurs définissent la violence obstétricale. Donc, violence obstétricale est une forme structurelle de violence sexiste, médicale et sexuelle perpétrée par des prestataires de soins et des institutions pendant la grossesse, l'accouchement et le postpartum. Le concept de violence obstétricale englobe un large éventail d'abus, de négligence et un manque général de respect à l'égard des femmes qui accouchent. La violence obstétricale réfère à diverses formes de mauvais traitements, de manque de respect, d'abus physiques, émotionnels, d'abus sexuels dont les femmes peuvent être victimes pendant l'accouchement dans les établissements de santé. Ou encore, les violences obstétricales se produisent pendant la période de gestation et peuvent inclure des abus physiques, sexuels et ou émotionnels perpétrés par un professionnel de la santé et impliquant des brimades, de la manipulation, de la coercition, des procédures non consenties et l'exploitation des différences de pouvoir. Si on devait résumer les différentes définitions qui sont proposées dans la littérature de la violence obstétricale et gynécologique, d'abord, ce qu'on constate, c'est qu'il y a beaucoup plus de recherches qui se fait sur la violence obstétricale que sur la violence gynécologique. Mais les paramètres demeurent sensiblement les mêmes. Ce qu'on constate, c'est que c'est une forme de violence qui est qui est systémique, qui repose principalement sur un déséquilibre de pouvoir entre les soignants et les personnes patientes, mais aussi sur les relents de paternalisme médical qui subsistent dans nos institutions et sur le patriarcat qu'on retrouve encore dans la société. C'est aussi une violence qui est fondée sur le genre. Donc, je vais parler probablement durant la présentation de femmes, de patientes au féminin, mais les questions de genre ici sont beaucoup plus larges que simplement les femmes cisgenres. Ça touche également les hommes trans, également les personnes non-binaires. Mais donc, dans le continuum des violences faites aux femmes, on retrouve toutes les iniquités dans les soins de santé, les iniquités dans la recherche sur la santé féminine qui sont faites, les iniquités dans les diagnostics et les traitements qui sont proposés pour les conditions médicales qui touchent particulièrement les femmes, mais aussi les stéréotypes de genre sur le rôle de la femme ou surtout le rôle de la mère dans la société. Et finalement, sur tout ce qui touche la non-croyance du vécu des femmes et de leur expression de la douleur qu'elles vont ressentir particulièrement. Finalement, c'est des violences qui vont porter atteinte aux droits fondamentaux des personnes qui vont les vivre, principalement leur droit à l'intégrité, leur droit de consentir de façon libre et éclairée, leur droit à l'autonomie et ce qu'on retrouve le plus souvent dans les témoignages des personnes qui vivent ces violences-là, c'est les aspects de leur atteinte au droit à la dignité. Et juste pour être extrêmement clair, les stérilisations forcées sont probablement au sommet de la pyramide des violences obstétricales qui peuvent être perpétrées. Donc, les violences obstétricales et gynécologiques ne se retrouvent pas dans la loi, ni au Québec, ni dans le reste du Canada. Cependant, le dernier plan d'action en périnatalité et en petite enfance 2023-2028, qui a été présenté par le ministère de la Santé et des Services sociaux du Québec, fait à son objectif 1.2 du choix éclairé la norme dans l'ensemble des soins et des services qui touchent la périnatalité et la petite enfance. Et on découle de cet objectif-là deux sujets principaux. D'abord, l'importance du consentement libre et éclairé, mais aussi la reconnaissance des violences obstétricales et gynécologiques et la nécessité de mettre en place une culture de soins qui soit respectueuse, sécurisante, non discriminatoire et non stigmatisante. Et le fait que les violences obstétricales et gynécologiques doivent être portées à l'attention des professionnels, des intervenants et du public en général. Maintenant, des illustrations. Je vais prendre les illustrations dont je vais vous parler du projet Parole, qui est un projet mené par ma collègue Sylvie Lévesque à l'Université du Québec à Montréal, qui est financé par le FRQSC, Secrétariat de la condition féminine et ministère de la Santé et des Services sociaux, et qui visait en fait par une enquête menée auprès des personnes qui ont vécu des soins obstétriques et gynécologiques dans les 7 dernières années, qui visait à déterminer en fait quel type de comportement ou quel type de geste a été rencontré le plus fréquemment. Donc, l'enquête s'est déroulée de juillet 2023 à janvier 2024. Et ce que je vais vous présenter, c'est les données qui découlent de nos échantillons de personnes qui ont simplement rapporté leurs soins le plus récents. Donc, non pas le soin violent qu'elles ont vécu, non pas un soin marquant, mais vraiment le dernier soin en date qu'elles ont vécu. Ce qu'on constate dans les données, c'est que près de la moitié des personnes qui ont répondu ont affirmé que personne ne s'était assuré du fait qu'elles pouvaient effectivement refuser le soin ou le traitement qui leur était proposé. Près de la moitié aussi n'ont pas senti qu'elles pouvaient remettre en question le traitement proposé ou la procédure qu'on voulait leur faire subir. Je vous laisse lire les données, j'en ai d'autres. 25% des personnes qui ont répondu ont affirmé ne pas avoir consenti à ce qu'un étudiant ou une étudiante fasse un test ou une procédure sur eux ou elles. 26% n'ont pas consenti à l'examen vaginal qui a été réalisé. 9% ont été forcés d'accepter un traitement ou une procédure autre qu'une stérilisation, mais pour les stérilisations, c'est 4% des répondantes de notre échantillon qui ont affirmé avoir subi une stérilisation sans les consentir. Et 6% ont rapporté avoir été obligés de signer un consentement aux soins, un consentement, un formulaire écrit de consentement aux soins, alors que soit elles refusaient ou elles n'avaient pas reçu d'explication sur ce que contenait le formulaire. Les contextes dans lesquels les soins obstétricaux et gynécologiques violents sont le plus souvent rapportés, bien évidemment, tout ce qui concerne la grossesse et l'accouchement. Mais au niveau gynéco, on a aussi eu des échos, des données du côté de la pause et le retrait des stérilets, particulièrement sur la prise en considération de la douleur qui est exprimée par les femmes. Évidemment, les stérilisations. Ici, c'est intéressant de voir qu'on a un double discours, c'est-à-dire qu'on a les violences rapportées en termes de stérilisation imposées, mais aussi le discours sur les stérilisations qui sont souhaitées, mais qui sont refusées par les équipes médicales parce que la personne est trop jeune et qu'elle va changer d'idée, évidemment, parce que tout le monde veut devenir mère dans la vie. Il y a aussi le contexte de l'endométriose. Ça se rapporte beaucoup plus à l'errance médicale. Donc, l'endométriose qui n'est pas reconnue, qui n'est pas diagnostiquée ni prise en charge. Et finalement, les violences aussi rapportées dans le contexte des soins de fertilité peuvent être particulièrement déshumanisants. Au niveau des impacts, on a documenté des impacts au niveau physique, évidemment, des douleurs qui ne sont pas prises en considération ou encore des douleurs qui vont se manifester, mais qui sont en fait le reflet des violences verbales ou des violences psychologiques qui sont vécues. Des impacts aussi sur les relations que les personnes vont vivre, soit avec l'enfant, donc difficultés par exemple dans le lien d'attachement, mais aussi avec les partenaires par la suite. Les plus grandes conséquences sont sur le plan psychologique et c'est ce qui est le plus difficile peut-être à prendre en considération. Il y a aussi des conséquences au niveau du système, donc la perte de confiance envers les professionnels de la santé, envers le système de santé de façon générale, qui peut mener même à un refus d'accéder à des soins par le futur. Donc, les extraits que je vous mets sont traduits en anglais, mais c'est des témoignages qu'on a reçus en français. Une personne qui nous dit ça remonte à un peu plus de 5 ans, mais j'ai pas fait de pap test depuis parce que je veux pas que personne, je veux pas réavoir mal comme ça, c'est hors de question. Une autre qui dit, tu sais, au point où j'ai menti sur mon bébé. Tu sais, il s'accrochait pas bien au sein, ça n'allait vraiment pas, l'allaitement et tout ça. Je comprenais très bien ce qui se passait, je comprenais très bien les enjeux. Je lui ai donné des petits cups de lait maternel que j'exprimais en cachette. Je me suis sauvée de l'hôpital. J'ai appelé ma sage-femme pour lui dire « Ouais, ça va pas ». Donc, refus de parler des difficultés de l'allaitement avec le personnel de l'hôpital parce que la confiance n'y était juste pas. Maintenant, quelles sont les réponses légales qu'on a regardées? Bien, dans le cadre du projet de recherche qu'on fait, on s'intéresse à 4 types différents. Je vais vous passer les détails des projets de recherche. On s'intéresse à 4 types de recours différents. Donc, un recours en responsabilité médicale, donc au niveau de la responsabilité, ce qu'on a constaté en regardant les bases de données, c'est d'abord qu'on a très peu de responsabilité qui va être reconnue simplement pour les douleurs ou du moins pour le vécu de la personne qui a accouché. Les cas qu'on a où on peut retracer des traces de violence obstétricale particulièrement, quand on va avoir une décision, c'est parce que le bébé a subi un préjudice important et c'est au niveau du préjudice subi par l'enfant qu'on va avoir de la jurisprudence. Au niveau de la déontologie, là encore, pas énormément de décisions. Et quand on a des décisions, c'est que ça porte sur des actes ou des paroles à caractère sexuel. Ça va être amené devant le conseil de discipline. Puis ça, on va avoir des décisions quand il y avait une connotation sexuelle dans les actes qui ont été faits ou dans les paroles qui ont été prononcées. Mais quand ça touche strictement le consentement aux soins ou juste la déshumanisation ou les atteintes à la dignité, on n'a pas de décision. Au niveau du droit criminel, ben, on n'a rien, bien honnêtement, à part des cas évidents d'agression sexuelle, c'est-à-dire où un médecin a profité du fait du soin pour causer une agression sexuelle. On n'a pas de pose de stérilet ou d'insertion de spéculum sans consentement qui ont été assimilés à des cas d'agression sexuelle ou de voie de fait. Ça n'existe simplement pas. Et au niveau de l'indemnisation des victimes d'actes criminels au Québec, qui est un système administratif, on a même refusé, c'est en appel, on verra ce que ça va donner, mais on a refusé l'indemnisation à une personne victime d'une stérilisation forcée en disant que ce n'était pas un acte criminel. Donc, à suivre. Celui qui nous semble peut-être le plus prometteur, du moins en termes de réponse aux besoins qui sont exprimés par les femmes, qui sont généralement de s'assurer que ça n'arrivera plus à personne, que leur vécu soit pris en considération et qu'on trouve des solutions. C'est le concept des commissaires aux plaintes et à la qualité des services qu'on retrouve au Québec dans tous les établissements de santé. Mais malgré le fait que ça semble correspondre le mieux aux besoins des patientes, c'est très peu utilisé. D'abord, c'est très peu connu. Et ce que les personnes à qui on a parlé pour le moment, on a 7 personnes sur 15 dans les entrevues qu'on a faites qui ont voulu porter plainte, qui ont réfléchi longuement, mais qui ont refusé au final de le faire. Et ce qui ressort beaucoup, c'est la crainte de ne pas être cru. C'est la crainte que ce soit la parole des professionnels de la santé contre la parole de la patiente et qu'au final, il n'y ait pas de décision en leur faveur. Et en ce sens, les témoignages qu'on a dans les entretiens qu'on fait sont extrêmement similaires aux témoignages qu'on peut retrouver en termes de violence domestique et de violence sexuelle, dans cette idée-là de ne pas être cru et du débat, de l'écart de pouvoir qu'on perçoit aussi entre les personnes victimes et les personnes qui ont fait les soins. J'avais d'autres extraits à vous présenter, l'histoire de la participante E02. J'ai pas eu le temps de passer à travers tout ça, simplement pour vous dire que dans son cas, elle a fait une plainte parce que la médecin, lors de l'accouchement, pour s'assurer qu'elle se tourne sur le dos, lui a dit soit tu te tournes, tu fais ce qu'on dit, ou on sort la ventouse. Le problème, c'est qu'une fois que sa plainte a été déposée, la médecin a simplement dit non, j'ai jamais dit ça. Et ça s'est arrêté là. Et pour cette patiente-là, ça a été la goutte d'eau qui a fait déborder le vase. Et c'est suite à la réception de la lettre du commissaire qui était très, très laconique et qui disait simplement, bon, on a une version contradictoire, on ne peut pas rien faire, merci beaucoup, au revoir. Elle a senti le besoin d'appeler sa psy et de recommencer à avoir des suivis réguliers avec elle pour finalement se faire diagnostiquer un trouble de choc, un choc post-traumatique. Et c'était intéressant de voir que cette participante-là nous disait, moi, je pensais que c'était les gens qui allaient à la guerre, qui avaient des chocs post-traumatiques. Puis là, j'ai réalisé que, ben non, tu peux avoir un choc post-traumatique de ton accouchement. Donc, qu'est-ce qu'on peut retenir pour le moment des projets qu'on mène qui sont en cours et les résultats que je vous présente sont des résultats préliminaires? Bien, c'est d'abord qu'il faut reconnaître et faire reconnaître les violences obstétricales et gynécologiques. Si on ne sait pas ce que c'est, si on ne comprend pas comment ça fonctionne, on n'est pas capable de les percevoir. Puis le danger, c'est de les recréer sans même s'en rendre compte. Parce que la plupart des soignants ne se lèvent pas le matin en se disant « je vais faire une violence obstétricale aujourd'hui ». Mais si on ne sait pas ce que c'est, ça devient difficile de l'éviter. Je pense que le dialogue aussi constant avec les professionnels de la santé est extrêmement important. Et finalement, mieux comprendre les mécanismes juridiques et continuer de comprendre qu'est-ce qui fonctionne, qu'est-ce qui ne fonctionne pas, quels sont les obstacles et les défis va être essentiel si on veut parvenir à mieux respecter, à mieux soutenir les femmes et leurs besoins en termes d'accès à la justice. Alors, voilà. Merci.
Merci beaucoup, Audrey. Ça complète bien, je trouve, la conférence d'Alisa et aussi celle de Seema. Alors, last but not least, we're going to hear now from Xaand Bancroft, She's currently a population health PhD candidate at the University of Ottawa. Her interdisciplinary academic background includes back in sciences, in psychology, in zoology, and both earned from the University of Guelph, a master's in environmental studies from University of Moncton, and a master of health administration from the University of Ottawa. Xaand's academic areas of interest include environmental issues, maternal and newborn care, health inequities, feminism, abolition, social justice, abortion, I suppose, social justice, and reproductive justice. Our PhD thesis explores care delivery to pregnant individuals incarcerated in Ontario, in Canada. And Xaand has a strong desire to support her classmates in achieving their academic and personal goals. She provides her peers with support through the Population Health PhD mentorship program. Xaand's academic and personal journey are motivated by her desire to advocate for and serve individuals and populations whose voices are not always clearly heard. So our talk today, the title of our talk is Consent and Care, the Experiences of Pregnant Individuals Incarcerated in the Province of Ontario, Canada.
Hi, everyone. I'm happy to be here today. And as was said in the bio, I think I'm just not talking close enough. I'm a PhD candidate at the University of Ottawa in the Population Health Program. And today I'll be talking about a small piece of my PhD research, which is related to the experience of individuals who are incarcerated while pregnant. I'd like to take the time to acknowledge l'Institut de Savoir Montfort and the University of Ottawa, who have both helped me work through this project. So this is just a quick outline. So I'm going to be talking a bit about my project and the literature review, the methods I've used, and at the end, discussion and questions. So throughout the presentation, I'm going to use the term woman and women, and I recognize that not everyone who gives birth identifies as being a woman, and the language is used to align with the language used by the province of Ontario and by the federal government. So I just want to know, has anyone who is here right now worked with people who were incarcerated while pregnant? Okay, so we have a few people. Okay, so can you tell me quickly where you were? Okay, so Amy is a TAC member of mine. So are you a midwife? Okay, and I saw another hand over here. Pardon me? Okay, perfect. So we do have a few people who have worked with people who were incarcerated while pregnant. And it's part of my study includes, involves interviews with providers and interviews with people who are incarcerated while pregnant. So the research topic for my PhD work is exploring the delivery of care service to individuals incarcerated in Ontario, Canada while pregnant. And it's a case study. So I'm looking at the experiences of providers who have worked with people who are incarcerated while pregnant, people who were incarcerated while pregnant. And I'm also looking at the policies and the laws and regulations in the province of Ontario, as well as in the federal government related to pregnancy and care. So within Canada, correctional institutions are managed by the federal government if a sentence is 2 years or greater, or if the person is over or equal to the age of 18. And the provincial and territorial governments are responsible for sentences that are less than 2 years and for individuals who are considered to be youth or minors, so below the age of 18. So there is just different types of security levels within the provincial facilities. So I'm not going to go through all of them, but you can see that there are treatment centers, there's maximum securities, there's detention centers. So there's different types of level depending on what the person's sentence was. So here we see a map of Canada. We can also see that within the correctional facilities, the majority of those who are incarcerated are men. So across the country, between 81 to 95% of the people incarcerated are men, and women represent between 5 to 19% of the carceral facilities. So if we just quickly look at BC, I'm just going to see, our technical person can click on BC up there. We might have. So there's different data and stats for each of the provinces in terms of the correctional facilities and whether the person is incarcerated in some facilities are mixed, which include both men and women, and some facilities are strictly men and some facilities are strictly women. So in the case of Ontario, Ontario has the highest number of correctional facilities across the country when it comes to the provincial level. So here we see that between 2012 and 2018, there are at least 5 mainstream media stories of horrific pregnant outcomes while people are incarcerated while pregnant. One that occurred in the Ottawa Correctional Facility was a woman who was pregnant. She was going into labor. She notified the correctional services, the guards that were there, that she was in labor, and they didn't believe her. She ended up giving birth in her cell, and it was a breech birth. She was by herself. She was brought to the hospital after she had given birth by herself in her cell. And a year later, the child passed away from complications due to their birth and the situation. So this is what got me interested in the topic of people who are incarcerated and pregnant and their experiences, because I thought to myself, if there's so many stories that have hit the mainstream media, there must be much more that haven't hit the mainstream media. So I was interested in knowing if anything had changed since 2012 with the occurrence in the Ottawa Correctional Facility. So in the literature review, we see that people who are incarcerated and pregnant have poor outcomes in terms of their own health, as well as poor outcomes in terms of the health of their newborns and their children. And these poor outcomes are also experienced once they have left correctional facilities and they become pregnant after they're no longer incarcerated. They still have poor health outcomes, both them and their newborns, compared to people who have never been incarcerated. So the purpose of my PhD research is to learn more about the experience of all individuals who are pregnant and incarcerated, regardless of pregnancy outcomes. So also looking at people who miscarried, people who gave birth, and people who chose to terminate the pregnancy. And the population of interest, as I said, is those who were incarcerated in the province of Ontario. So Ontario has 1 federal correctional facility, as well as the provincial managed facilities. So the methods I use, I got approval from University of Ottawa, REB, and I did participant recruitment through different means. Some include social networks, some include my networks of colleagues or researchers, and also through different, attending different conferences and trying to recruit there as well. And in total, I have 8 semi-structured interviews for people who were incarcerated while pregnant. And they have the choice to do their interview in English or French. All of them chose to do it in English. And after that, I did thematic analysis of the data. So here you can see some of the characteristics of the participants who were incarcerated while pregnant. Their sentences range from 3 days in the provincial facility up to 2 years off and on, going in and out of the correctional facilities. So some of them have miscarried while incarcerated. Some of them have given birth after leaving the correctional facility. All of them, their sentences were all in provincial facilities, so none of them that I interviewed had federal charges. So we talked about informed consent earlier from everyone who's been on this panel. So people should get the information to allow them to make a decision, that they should have all the information they need to make an appropriate decision. They should know the risk, the benefits, and the alternatives related to that. So in today's talk, I'm just taking a little, very small subset of the data that I've collected that speaks specifically to a lack of informed consent. Most of the examples are related to medical treatment, but there's one example that's not a medical example, but it still relates to the lack of consent. So when we talk about getting into the correctional facility, the first part is admission. When they get admitted to the correctional facility, they have to go through a scanner, which is like an X-ray machine. So when you're pregnant, you're not supposed to go through X-ray machines. So in this case, the participant was 27 years old at the time of her admission, Caucasian female, and her sentence was about 1.5 years. And she was 4 months and 22 days pregnant when she entered the correctional facility. She was being admitted and she wasn't yet showing, so she didn't look pregnant. And she let the guards know that she was pregnant and that she didn't want to go through the X-ray machine. And here we see what she said. She said, I told them that I was pregnant and I was not showing. I was probably about 4 months pregnant. I was showing a little bit, but they didn't believe me. I told them, like, I'm pregnant, and they put me through the scanner. anyway, and told me they had me go for blood work and pee test the following day. So they still put me through the scanner and everything, and I don't know, they just didn't believe me. So in this case, she raised concerns about the fact that she didn't want to go through the X-ray machine because she was pregnant, and she didn't want to put herself at risk, nor put her newborn or her fetus at risk at that time, and she wasn't believed by the correctional officers. So they sent her for blood work the next day rather than doing another means of search. So they go through the X-ray machine to see if they have any drugs on them. Usually that's what they were looking for, or any types of weapons that could be hidden. So in this case, she wasn't informed of the potential risks of going through the X-ray machine, nor was she even believed at the time that there could be, that she was pregnant, although she was telling them she was. They also, people who get incarcerated while pregnant receive different types of medications, and there's administration of medications throughout their stay there for different reasons. And some people have addictions and need to be on methadone. Some people have difficulty sleeping, and there's different reasons why someone might need medication while they're incarcerated and pregnant. So for this participant, they were 34 years old, Latina female. Her stay was 3 days. She was 7 weeks and 2 days pregnant. She was in the correctional facility when they confirmed her pregnancy. So before she got to the correctional facility, she didn't know she was pregnant, but she kind of had a suspicion, and she asked to have a test done, and it was confirmed that she was pregnant, and she was looking to get some medication. So she says, and then the medication I get, they remove the gravel because it's not good for pregnant. They call it a cocktail. It's like clonidine, Imodium. I don't even know exactly. It's things that maybe like help you just calm down if you're not on any prescribed anything, because they can call your pharmacy and like send it over and whatnot. So send over the prescription. So I had nothing. They just gave me that. So I was fine with that. So in this case, she received medications, and she wasn't aware what the medications were for. She wasn't sure what was in the cocktail. So she didn't get any information about the medication she was receiving. And so she didn't actually give informed consent, because she just took what they gave him and she just moved on with what was going on there. So in this case is another example of a lack of informed consent when it comes to medication. For our following participant, she was 24 years old at the time of incarceration, Caucasian female. She had several stints in and out of the correctional facility. So one was 14 days and one was 2 months. For the first stint, she was 4 months pregnant, and the second stint, she was 6 months pregnant, and this was for the same pregnancy in this case. And she was incarcerated. She had a history of substance use, and she was going through withdrawal, and she wanted to be able to sleep at night. So in her experience, so he gave me this medication, but this medication really fucked with me after. I gained so I went up to 220 pounds after, just from this medication. I struggled to get off it. It was actually an antipsychotic. Yeah, there should be more this is the risk of the medication. This is the side effect. This is there should be more options. This medication does this or this. But anyway, so he didn't tell me all of that. He just told me it would help me sleep, and that's what I was looking for. So this is another example of them getting medication without informed consent, without knowing the consequences of the medication, without knowing the side effects, and not being told either if there was any alternatives to the medication that she was receiving. And this is upon release. This client was 31 to 35 years of age when she was incarcerated, Caucasian, non-binary person. She spent 3.8 months in the correctional facility. She was 7 weeks when she entered the correctional facility, 7 weeks pregnant. She had an ectopic pregnancy while she was in the facility. She was brought to the hospital to receive an injection to essentially dissolve the pregnancy. And she was brought back to the correctional facility rather than staying overnight for a few days at the hospital, which is, from what my understanding, would be the normal procedure. So she went to the hospital, got the procedure, the injection done, went back to the correctional facility. And then while she was at the correctional facility, her release date came up. So she had never gone back to the hospital, and she had never gotten more information about what was going on with her body, and if the medication they had given her actually dissolved the pregnancy. So she said, So I had done the blood work twice, but never gotten the results back yet at the prison. And so I was released without any information. Like I had no idea what was going on. I had no idea if it had been successful. If it hadn't been successful, what had happened? Did I have to do a follow-up? So she wasn't given any information about the procedure, the success of the procedure, whether or not it went well. She didn't get any follow-up information. So she had a lot of unanswered questions. So it's another example of lack of informed consent through the process of correctional facilities and people who are incarcerated while pregnant. These are just examples of what they can experience. So in terms of discussion, we see that there's clearly some health disparities in terms of access to care for people who are incarcerated while pregnant. And they're also dealing with compounded issues. They're dealing with addictions. They're dealing with being incarcerated and managing the consequences of being incarcerated as well. There's systematic violations of autonomy, so they don't get a choice when they should be getting choices about their own care. And there's legal and ethical breaches because they're not being told exactly what something can do to their bodies. They're not being given informed consent. They're not being given options about the procedures that they could be having instead. And it fosters mistrust. So many of the participants express mistrust towards medical services within the correctional facility and as well as medical services within the community. So it highlights the needs for policies to ensure informed consent for people who are incarcerated and pregnant, and changes in practices are required to ensure that people who are pregnant as well as their fetuses are protected from not being informed of the consequences of certain medications or procedures that are being done while they're incarcerated and pregnant. So.
Much for this last presentation. There's a lot of interlinks with all the presentation. Thank you for this really excellent second panel of the day. Thank you for keeping up with time. This was easy. So it leaves us time for questions. So the floor is now yours. So if you couldn't go to the mic, we have until 45 and we will be back on tight on schedule. So if you have any question, that's the moment. I might have one for Audrey. Est-ce que dans l'analyse des statistiques, je comprends que les recherches ne sont pas toutes terminées, mais est-ce que vous prévoyez être en mesure d'établir finalement justement les inéquités entre les différents groupes dans la population? Puis remarqué que vous aviez, pour faire un lien avec la présentation d'Alisa, qu'il y avait 4% de stérilisation forcée. Il y avait aussi, pour faire le lien avec les autres présentations, plein d'autres points là, comme le non-respect, le distrust, a lot of distrust in all of these presentations. Donc, est-ce que, par exemple, les populations autochtones peuvent être particulièrement ciblées, etc. Donc,
c'est une bonne question sur notre échantillon. On n'est pas encore à l'étape de faire les analyses de corrélation entre les différentes strates qu'on a. Par contre, dans la littérature sur les violences obstétricales et gynécologiques, c'est très présent. L'intersectionnalité va amener un plus grand risque de subir des violences obstétricales chez les populations racisées, les populations autochtones, les très jeunes mères, les personnes âgées, les femmes âgées sont aussi plus à risque d'avoir des violences gynécologiques au moment notamment des examens gynécologiques. Et les personnes avec un statut socio-économique plus faible, une éducation plus faible, aussi sont plus à risque de subir des VOG. Et ça, on le voit déjà dans la littérature américaine, en Europe, Amérique latine, je veux dire, c'est partout. Je ne pense pas que notre échantillon va être différent. Est-ce qu'on va être capable d'avoir des chiffres qui sont statistiquement significatifs en termes d'analyse mathématique? Je ne sais pas si c'est trop tôt encore pour le dire, mais ce qui est certain, c'est qu'il n'y a rien qui nous laisse présager que notre situation au Québec serait différente.
Thank you. We have a question from the floor.
Hi, my name is Véronique Pronovo. I have a question. Oh, first, thank you for the great panel. It was really, really interesting. I have a question regarding the first presentation and fetal personhood. So in 2004, George Bush signed into law the Unborn Victim of Violence Act, which was granting a status of legal victim to embryo and also fetus. There was a provision for abortion, so it was not giving fetal personhood completely, but I was wondering, in your case with IVF, is there an interaction possible? Can it be used to actually criminalize or prohibit IVF in the States? Thank you.
Yeah, so thank you for that question. So obviously, at that time, the reason that it had an exception for abortion was because Roe versus Wade was good law. And so because now we don't have that federal protection, you know, kind of it's all fair game. And in terms of your question about whether it can be used for IVF, it depends on the actual language, because interpretation, you know, usually the ASRM did a study, the American Society of Reproductive Medicine did a study before, right after the Dobbs decision came out, to show that, you know, at that time, all the state laws were talking about it in the context of a pregnant woman, like an embryo in the context of a pregnant woman. So it wasn't going to be an embryo outside that's not impregnated that would be considered it wouldn't be an issue. It's after Dobbs that we've been seeing interpretations and case law that is starting this interpretation. And this is the kind of the next goal for the anti-abortion movement, is recognition of fetal personhood. And what we're seeing is, even in completely unrelated cases, like cases about mifepristone, which is one of the medication abortion drugs, and out of Texas, one of the cases, the lower court cases, the federal judge kept talking about a baby. You know, when they're talking about embryos, they did not make the distinction between a fetus and embryo. It was all talking about a baby. And we're seeing more language like that in the lower courts. You know, one of the reactions to these kind of overbroad abortion restrictions is carving out an exception just for IVF. And so that is what Alabama did after the LePage decision. They passed a law that basically said, well, IVF providers are not going to be liable, but it specifically did not talk about whether a fetus, has any of the rights of a person, and it did not preclude that. And there's many reasons why just exempting IVF, a lot of states have done that, is not really promoting reproductive justice. It's much more important to have a broader outlook for many reasons, not just looking at this. And so I think this is something that we're going to be tackling for years to come. And it became an election issue because Trump realized, and the Republican Party realized, that this was not a popular issue. But I think the reality of how it's going to be governed is going to be different than what was said during the election.
Thank you, Seema, for the answer. Yes, we have another question.
Yes, I am just really excited. Thank you so much for all of your presentations. I'm just really excited to ask, the few of you who are working around consent and informed consent and coercion, and the work you're doing is very important within the context of the medical context. But I wonder as well about the relationships to various systems, such as child welfare systems, like you're working within, prisons, and in work that I've done around informed consent, I've really been struck by some of collaborators who talk to me about how the system's treatment of them led them to make decisions that they later did not think was maybe the decisions they should have made, even though they had healthcare providers who are very supportive within that context. So I think about the child welfare system, removing children from women, and then creating this insurmountable hoops that they need to jump through, and not wanting to go through that again, or making decisions to terminate a pregnancy because of how the system is regulating them and their children and not allowing them to have that relationship. So I'm thinking about that specifically, but other relationships to systems, I'm also trying to get there.
That's a great question, Professor Mackenzie. I've certainly seen it in the context. Is it Mackenzie or no? Oh. Yeah. Well, you know, you've earned your stripes. You're Professor Mackenzie. I think that that's a great question. And the intersection between the systems as we've observed them on the ground are tremendous, of course. Many of the women that we represent or who are involved as putative class members in this class action, which is going to certification, by the way, December 9th to December 13th, at long last. The last class action that was certified in Saskatchewan took 12 years. So I'm not sure why it's particularly slow there, but there you have it. Those are the timelines. Going back to your question in terms of the intertwinement with other systems, yes, that's something that we see quite frequently, CFS, in particular Child and Family Services. And with respect to birth alerts, for example, I'm sure that there are other instances, but I can tell you that I've heard from many a woman who was aware of a birth alert on their file that had been communicated to a hospital and then decided to cross a provincial line to have their baby out of fear that their child would be apprehended, as they often are. And so it kind of goes back to the systemic issues, the systemic solutions, right? What are the grounds? What is the justification for the apprehension? What we've seen with respect to birth alerts, for example, which also forms the basis of several class actions across the country at this moment, is that the concern has to do with the unborn child and the protection of the unborn child. But of course, that child is not a person in Canadian law, and so we cannot breach the privacy of mom in notifying any kinds of hospitals that birth is impending and so on and so forth. And so that's how we see those privacy breaches as emerging. But again, that's just a tiny piece of the pie. What we've also seen are some of these women, these pregnant women who were themselves as children involved with the CFS system. And somehow by the time they decide to have children or get pregnant, sometimes they're young, sometimes they're not, they essentially have to prove to CFS that they are worthy of motherhood before they let them keep their child. And this is verbiage that I have heard from several women. Oh, they let me keep this one. So the default is they will lose their children. I think that puts the onus in the wrong place, quite frankly. And there's never really a question of justification in those circumstances. It's, well, you've been in CFS, your mother was in CFS, clearly you can't be a mom, so prove to us that you're going to be able to be a good mom and we won't take your baby. These are the kinds of circumstances that are actually happening on the ground. And I mean, we can look at the law and understand that that's not how that's supposed to function, because it's not. But the fact of the matter is that access to justice for marginalized women is evasive. And it's evasive because it's expensive, but it's mostly evasive because people don't believe them. Or, to be really honest, they believe that they deserve what is happening. I remember when this case first started, the forced sterilization case first started, we had instructions to raise awareness. And so we went on the radio and the television quite a bit, much to my chagrin, but we did do that. And one of the first questions that was asked of us, which really spotlights the stereotypes, one of the first questions that was asked of us, well, Ms. Lombard, don't these women have several children that are already in care? The answer was and is no. Why would you think that? Well, isn't that, there's more and more of these children are taken from Aboriginal moms or Indigenous moms. Yes, those are the statistics. But the women we represent actually, no, their children aren't and have never been in care. And one of them has 2, the other one has 3, one has 6. Never been in care, no? Well, and I said, well, but what if they were? What if they were in care? What about that set of circumstances displaces the physician's obligation and the institution in which they operate and have privileges or are staff practitioners from obtaining proper and informed consent? Well, nothing. So why does it matter? Well, because some people think, and I said, thank you for illustrating the very problem that causes these heinous human rights violations. So I don't think he intended for it to end that way, but that's how it ended.
Peut-être juste ajouter que on a eu des cas rapportés dans les projets de coercition informelle. Je pense que ce qui nous distingue un peu des États-Unis, parce que moi, ça m'avait frappé, aux États-Unis, il y a des cas de coercition formelle, c'est-à-dire que l'hôpital va aller demander carrément une injonction au tribunal pour forcer une femme à avoir une césarienne, par exemple, en disant sinon, on retire le bébé, on le met en protection de la jeunesse. Chez nous, un tribunal ne l'autoriserait pas si la personne est apte à consentir, mais est-ce que l'équipe médicale peut faire jouer sur la crainte d'appeler la DPJ, par contre? Oui, tout à fait. Puis ça a été rapporté dans le projet. Ce qu'on a aussi, c'est les femmes qui vont essayer d'éviter des violences obstétricales à l'hôpital et qui vont faire le choix d'accoucher seules à la maison. Et là, elles s'embarquent quand elles vont retourner à l'hôpital avec le bébé. Là, on va présumer qu'elles sont inaptes à s'occuper de leur enfant parce qu'elles ont fait le choix très dangereux de donner naissance seules à la maison. Et là, elles risquent de s'embarquer dans un cercle vicieux de... On n'appellera pas nécessairement la DPJ sur le coup, mais on va faire miroiter cette possibilité-là, puis on va s'assurer de bien faire comprendre à la personne qu'elle est sous surveillance. Si on le veut.
In my study, what I found with the interviews with the providers, so you have the correctional facilities that are managed by the province, and you have the healthcare facilities that are managed by the province or that are private, but most of the time they bring them to a facility that's managed by the province, a healthcare facility that's managed by the province. So when they're transported from the correctional facility to the medical facility, you have the intersection between both facilities. So you have your correctional facility, your medical facility. They get there, they're with guards. A lot of the time, the guards stay in the room with them while they're having whatever done, which is a breach of privacy. And the providers who are, let's say, in the hospital for this example, don't really know what they're supposed to do with the guards. And they don't really know who is, quote unquote, in power when the correctional officers are with them in the room. So there's been times where some providers said like they wanted the person to stay longer at the correctional facility, not at the correctional facility, at the healthcare facility to give mom and baby time to bond. So the provider would advocate for them to stay longer, but the correctional officer who has no medical background would push to bring the client back to the correctional facility. So we're encountering this overlap between two facilities and different types of providers. And there's confusion or lack of clarity between who has authority in these situations. So even when they're in the hospital, for example, hospital staff will see the correctional officers as having authority over that person when in reality they don't. And then it hinders the medical professionals' ability to do their work the way they normally would do it if it was someone who wasn't in a correctional facility. So we're seeing that also in this study, and also the same thing with Child Protective Services comes on as another piece that's complicated, I think. So there is definitely that overlap between all the systems, and it makes it very complicated for someone to get, I guess, regular standards of care.
Yes.
My question relates to both obstetric and gynecological violence and also forced sterilization. So on the part that you mentioned, well, I do agree that during labor, especially at certain points, women that are giving birth are not able to consent to procedures that are permanent, for example, the sterilizations, and it's not necessary in that moment. But my question is, what's stopping those who lean in favor of physician discretion from using that same argument in cases of trying to infringe on their patient autonomy for procedures such as birth positions, the use of whether going for vaginal birth or cesarean section, that what's stopping them from using that same argument to favor physician discretion?
Yeah. Audrey, veux-tu répondre à la question? J'ai pas tout bien compris. I did not get everything, but maybe Audrey got it.
Repeat it if you
I
like.
don't want to answer. I just want to wrap up. I think Alisa was saying that women cannot really consent to sterilization just after giving birth. So I think what is being asked is what's the difference between not being able to getting a sterilization versus a C-section or bird position or IPSIO or, yeah.
So the consent framework really operates on a spectrum, right? It depends on the severity and the permanence of the procedure and its relative urgency or necessity, right? So if we're talking, I'll just use my own experience. Sorry if this grosses everybody out, but the only thing we can use are our own experiences. So my second daughter was born what's called sunny side up. So then they have to change your positioning, right? And that was helpful because eventually she was born, and boy, is she ever around now. But the issue there is that there was nothing permanent about that birthing position. There was nothing irreversible about that birthing position. And it was just going to make my life easier if they put me in that position, as it did. If we're looking at C-sections, in many instances, if you've reached the point where a cesarean section is required, it's because there is a danger to the baby, their heart rate is diving, mom has a fever, something is happening where it becomes increasingly emergent for there to be an intervention to actually save the life of mom and baby. When we're talking about a tubal ligation, it is considered by the literature as non-therapeutic, which means it's not medically necessary. It's also not an emergency in any particular instance. And I think it's also important to distinguish. Some people have, for example, said, well, if a woman consented to a C-section, and then one of the risks associated with that C-section is, for example, something happens to her tubes or her ovaries or what have you that impairs her fertility, well, that's a risk with another primary procedure undertaken for the purposes of either saving her life or delivering the baby safely. So a tubal ligation just doesn't sit on the same, it's on the opposite end of the spectrum when it comes to these other types of interventions, which are either emergent, necessary, or not permanent, such as a birthing position. I don't know if that answers your question.
Am I able to please go for a follow-up? Is that okay? The follow-up.
Oh, follow
Yeah,
up.
just for clarity. So I do understand what you just mentioned. I'm just worried about the fact that, a forced sterilization is at the peak end of obstetric violence. So what about other procedures that are not maybe considered as drastic? And also there have been cases where physicians would opt for maybe C-sections for their own, what's it called? Is it convenience? Yes. And this is going into the realm of obstetric violence. And how would that be navigated? Because it will essentially turn to a case of the patient versus the doctor's words. How could we secure women's rights in those type of situations where they could have the argument where, well, I have the physician discretion, or they could deny what happens in the labor room? How can that be navigated as well?
It seems to me there would have to be an indication requiring a cesarean section. And so if you pre-schedule one because the doctor's going on a cruise the next week and they don't want to have to show up at the hospital, that's a completely different story. And I think something that we have to mention here too, that maybe for me is a pink elephant in the room, is that physicians have fiduciary obligations to their patients. That relationship is fiduciary in nature. That does not mean that they do what they think is right for themselves or their family members or what have you. That means they have to ascertain the will of the patient when it comes to procedures associated with them. And so if we're talking about C-sections of convenience, and we've heard about them quite a bit, that I mean, it would situate into a non-therapeutic procedure, which would require the same amount of disclosure and consent requirements as a tubal ligation. And if it doesn't, well then, not good.
Thank you.